on this morning's Ag Issues program. A pleasure, as always, to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thanks.
All right, let's get to it. We got plenty to talk about. And if you were listening last hour to the Monday Agricultural Law and Tax Report, you actually talked about this topic, and that is the Form I-9, which, as many ag employers who hire workers, they know definitely what that is because that's required documents as well. But there's some updates on that you have concerning the Form I-9 and some of the things that have been going on with that.
Yeah, this is a very important document, Greg, and it's changed, and farm employers need to be aware that it has changed. And this is a good document that protects farm employers from getting in trouble for hiring people that they cannot hire under the law. Some may remember a few years ago there was a farming operation in Iowa that came under scrutiny for hiring an illegal alien after there was a murder that individual did in a rural area in Iowa. It came back to that farm that they had some hiring practices that need to be checked into. So the I-9 can be very important to protect employers. So we don't want to think of it just simply as, oh, here's another form I got to fill out. The government's messing with my business again. Well, it can actually be a very good document for you. So what it does is verify the identity and employment authorization of farm employees and make sure that you're not hit with penalties for improper hire. So we want to be making sure that we're hiring the appropriate people in agriculture. And there was a new version of the form that became available August 1, and it's out there. And I linked to it in my recent blog article on this topic, as well as the new instructions. And this is the one that this version becomes mandatory starting on November 1.
And are there big differences as far as the revised version of the Form I-9?
Not terribly big differences. The form has been condensed in some instances. It does clarify the difference between non-citizen national and non-citizen that's authorized to work. And they've made it such that the form can be filled out now on a tablet or on a mobile device. And they put a checkbox on the form for employers to indicate when they have remotely examined the Form I-9 documents that a potential hire has filled out. They've made some other revisions to it, and the instructions have also been updated. But this is, you as a farm employer, you have to make sure that the I-9 has been properly completed for everybody that you hire, and whether you have to indicate whether your hiring involves citizens or non-citizens. And the other point I would make, Greg, is that often in agriculture, in fact, why we have the whole domain known as agricultural law is that the law often treats agriculture and agricultural activities different than it does non-agriculture taxpayers and businesses and activities. But not in this instance. That's not the case when it comes to Form I-9. There is no exception based on the size of the farming operation. There's no exception for family-owned farm businesses. This applies to everybody. And so everybody in agriculture has to pay attention to this.
All right, let's get to another topic here, and one that we've heard a lot about here the past, several years, and that is ownership of U.S. land, but specifically agricultural lands that are owned by foreign persons or entities. Of course, this has been a long time issue, you could probably go clear back to some of the origins of the United States today as well. But there was a recent case concerning the foreign ownership law for, I think it was in Florida, as a matter of fact, that an injunction was tried to be put in place.
Yeah, that's right. And you're right, foreign ownership laws have been part of the country since its formation, and really it dates back 10 centuries. We could go to 1016 AD in the Norman conquest, where William of Normandy crossed the English Channel and claimed what we now know as England as his own, all of the United Kingdom. And he realized he couldn't farm it. He needed other people to farm it, and make it productive and have it produce things, and he wanted those people to be loyal to the crown. And so your first restrictions on foreign ownership or foreign holdings in agricultural land date back actually to just shortly after 1016 AD. And it's an issue of food safety. It's an issue of protection of the food supply. And that was an issue that came up in Florida recently because we've had a number of states that have enacted legislation in the past couple of years, and the issue has come up in Kansas. Now, Kansas hasn't done anything additional to the anti-corporate farming law that we have in place right now, and that's really where a restriction is at, if there is one in Kansas, on foreign ownership or foreign holdings of land. But they are continuing to consider legislation that would make it more restrictive. Excuse me. There are other states that have much more restrictive laws, and the Florida legislation this past year, they've really ramped up the restrictions in Florida. And all of this, Greg, is being set off in legislatures, and has grabbed legislative attention because of what Chinese investors have been doing in terms of buying agricultural land in strategic areas, such as their military base in Grand Forks, North Dakota, a couple of strategic purchases in Texas as well as in Florida. And it's gotten the legislatures in those states, as well as elsewhere, it's gotten their attention. And so what basically they've come up with, they said, if you are a non-U.S. citizen that is a citizen of a country of concern, is the way that Florida defined it. There's also another way to define it. If you're on the foreign adversary list, which is a federal list of what we deem to be bad countries that would do us evil. And so you think on that list, you think of North Korea, you think of Iran, you think of Russia, you think of China, Venezuela, the Maduro regime, and other places. There's a handful of those that are on the foreign adversary list. And some states will try to tie into that list to say, look, if you're a citizen of those countries or you're connected to the government in those countries, however the state defines it, then there are certain restrictions that come into play with you owning or holding an interest in agricultural land in this country. Well, Florida enacted their law. It went into effect on July 1 of this year, and it limits land ownership rights of certain non-citizens that are domiciled either in China or other countries that are a foreign country of concern, and that's the key term here. And those are your countries that include China and some of those others. And there were 4 Chinese citizens, as soon as the law was enacted a couple of weeks later, that live in Florida, along with a real estate brokerage firm, that claimed that the law violated their equal protection rights because it restricted their ability to buy property due to their race. And they also claimed that the law violated the Due Process Clause, the Supremacy Clause of the Constitution, and the Fair Housing Act. Well, under that law, Chinese investors that are not U.S. citizens that hold or acquire an interest in real property in Florida, starting July 1 this year, had to report their interest to the state or potentially be fined $1,000 per day that the report was late. And Chinese acquisitions after that date were subject to forfeiture to the state, with the acquisitions constituting a third-degree felony. And the seller also would get in trouble. It would be a first-degree misdemeanor if they knowingly sold the property to somebody they knew was on the list that they didn't have permission to or authority to sell to. So the plaintiffs sued, and they wanted an injunction imposed so that the law would not go into effect while the case was being litigated. But the court said no. We are going to let this law go into effect, and it is into effect. The litigation is pending. It's just that the injunction was denied because the court felt that the plaintiffs in this case would lose. He said, this is not race-based. This is based on what we call alienage, where you're from. Greg, it would apply to you and I if we were Chinese citizens trying to buy land in Florida. It's not race-based at all. It's just based on where you're from. And if you're from a country that is and you're domiciled there and you're not a U.S. citizen, the court said, well, just become a U.S. citizen and you're okay. And so the court dismissed every single point they made. It doesn't violate equal protection. It doesn't violate the supremacy clause, because the court said that Congress has allowed states to do this. They haven't overridden states' ability to restrict foreign ownership of agricultural land, even though there is a federal reporting law. It doesn't violate the Fair Housing Act. The court just denied every single claim, pretty much out of hand, that the plaintiffs had raised in this. So no injunction, law goes into effect in Florida, and the case continues. But I do think it'll be instructive for other states considering similar legislation, because look, now you've got a federal judge that has said race is not a concern here. And the court said the concern is the food supply, food safety, and it's based on alienage.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us. And Roger, another thing we want to cover concerning USDA payments, but specifically looking at underserved farmers in high poverty areas and payments to farmers that have allegedly been discriminated against by the USDA, but looking at that specifically as to whether they are non-taxable or not.
Yeah, that's what the attempt is here, Greg. This is fully partisan legislation that has been introduced into the House. There's no bill number yet. And what it would do is make numerous farm program benefits non-taxable. Now, there was identical legislation that was introduced into the Senate late last year, and this is called, if people want to look it up, the Family Farmer and Ranch Tax Fairness Act of 2023. And again, certain types of payments that come out from USDA to certain types of recipients would not be taxable. Now, none of the USDA program payments that the bill makes non-taxable are associated with the virus. And so that's kind of like going to be a catch point here when they try to get this through both bodies of the Congress. This doesn't have anything to do with the virus at all. Now, while the bill could end up being included in the Farm Bill, which I don't think has virtually any chance of clearing this year, I think we'll just get an extension on that. But I would say this bill makes little tax or economic sense, and you're going to get perverse economic incentives anytime you make something, an accretion to income, not taxable. And so I think it's going to face stiff opposition, but I thought people would find it interesting to know that Congress is trying to do this. And another announcement that came out last week, they're trying to provide some type of economic benefit to people. But last week, the IRS came out and said, well, we're not going to process any more employee retention credit claims this year. The ERC has fraud, and anytime the government has some type of financial program, there's always some level of fraud associated with it. But for those 90%, the estimate is 90% of claimants that have legitimate claims for the employee retention credit. Now, that's virus-related legislation for businesses that had to dismiss people, and this is to help the business survive, basically. There are a lot of small businesses across this country that depend on that, and now IRS will no longer be processing claims for the rest of the year. And you combine that with higher interest rates if they need to rebuild their facility or retool it, and now you can't get the employee retention credit. I wonder what the shakeout of that is going to be throughout the economy. And not so much on the farm, but input suppliers to farmers depend on that credit. So that's another one that's out there, Greg. I just want to throw that one in this morning.
All right, let's go into another topic as well. And this, if you're a landowner, one of the more important considerations on this is considering leasing their land for hunting concerns, and that could be potential liability sustained or caused by hunters on the property as well.
Mm-hmm. Yeah, well, apparently not for turkey hunting this season in Kansas. I heard you comment on that this morning, and that came out late last week. By the way, I have no idea how they measure turkey population and turkey births and deaths, but anyway, other than the one I hit with a pickup truck a number of years ago when my son was small and was riding in the passenger seat of my pickup truck, and this was on northern Riley County heading west on 16, and there were the ground was high, and the road kind of went through a couple of high places, and the turkey comes. Big Tom turkey takes off, and he can't get elevated, and he smacks into the windshield and just shatters it all over my son. So I took that turkey out. That was out of season, but I guess if you pick him off with a truck, that's okay. But yeah, when you talk about leasing land for hunting, I think probably one of the most important considerations would be, as you mentioned, potential liability. Well, Kansas has a recreational use statute that, if you can fit within its confines, will provide some type of liability protection for you. And all states do that. Now, the other things, there's some other things that you want in a hunting, I call it a hunting use agreement. It's not really a lease. It's just a license to use the property for hunting purposes. So you give somebody a contract right to come on your property for what you define they can do, what type of hunting and what type of weapons they can use, those types of things. And so get your understanding in writing and include in that contract who the parties are, who's allowed to be on the property, what they're allowed to do, the types of hunting that it's allowed, when it's allowed. I would put a termination provision in there too, and any options for renewal and a liability waiver and indemnification language too, and put payment terms in there. And I think it'll better serve you and help reduce misunderstandings in the future. But again, a lot of people don't do that. It's just a suggested approach if you want to get into kind of long-term engagements with people to give them hunting rights on your farm or ranch.
The best turkey story I have is our old location back up on Vinegar Hill. I was down in the lobby with our receptionist up front, and all of a sudden we see this big Tom start running towards our front door, and we had the reflective cover on the door itself, so he sees himself, and then he's going, I don't know how fast, but he runs smack dab right into the door, and then he's kind of looking around going, anybody see that type of thing? So that's the best one I have.
Survived. He survived that one, huh?
Yeah, he survived. Embarrassed, but he survived.
The one that ran into the one that flew into my windshield did not survive.
All right. Hey, Roger, if anyone wants more information, as you mentioned, a very informative one this time, all they need to do is they can go to your blog.
Yeah, washburnlaw.edu/WALTR down the left-hand side. You can find a link there. Also over on Ag Manager at K-State through the Department of Ag Econ, that website there.
All right, sounds good. Roger, as always, I appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.